All right, hello everybody. Keller Williams Partners. I am Chris. I'm going to be running through the purchase contract today. This will not be a line by line nitty gritty legal detail of it like I have done before in some classes. This will be an overview of the contract, the key parts and contingencies, things like that. Really kind of how to fill it out and what these blanks mean. So. I'm hoping this to be about an hour 15 long, and maybe a little bit shorter, depending on who's on and such. Right now, I'm going to be pretty free of questions, so we'll try to rail through it. Yeah, so that's about it. So first off, the purchase contract is a contract. It is not a contract until everybody signs it. So in some other states, they have what's called an offer for sale or an offer for purchase, and that you turn that in, and that details out things, and then they actually take those details and put them into a contract. So you have actually multiple documents there. Whereas in Arizona, this purchase contract is used as the offer up front. So the buyer fills it all out with their requested terms. They send it over to the seller. And if the seller were to agree to everything, they just sign it, and now you have a contract instead of having to translate all of that to an additional document. So we kind of streamline it here. That also falls in line with the fact that Arizona allows real estate agents to work in real estate contracts just in the same exact manner as a lawyer would. So we have a fairly high barrier of responsibility. There a high level of responsibility and fiduciary in the fact that as far as real estate is concerned, real estate agents are treated in the same manner lawyers are. As far as contract language in real estate. So take that seriously, obviously, because that's a significant thing, whether you are adding some language, interpreting some language, or just filling in the boilerplate details. When you're advising your clients about the contract, you are in essence the legal representation of them regarding this real estate contract. Now, your legal representation stops at real estate, so don't send outside of that. And your legal representation isn't true legal representation as in a court of law. It's just basically in the creation and interpretation of documents having to do with real estate. So that was more information that you needed to know, and also very, very good information to have in your hand as far as responsibility. So the purchase contract has been through many, many revisions in its lifetime. Right now, it's about 10 pages. Covers a lot of things, everything from the actual purchase price to the inspection periods to how you handle FERCTA or lead-based paint. So all that kind of stuff is all built into it. Even our duties as real estate agents, as brokers, and that kind of stuff. It kind of lays a lot of those instructions out. And for those instruction details, I just highly encourage you to read it and see what you understand or don't understand, and come to me if there is something that you don't understand, and we'll talk about it, explain it. That honestly cuts this episode, this like line by line purchase contract, what that would be. That's probably 4.5 hours. I'm going to cut that line by line kind of stuff out. So we're going to talk about the gross details rather than the minutia. The purchase contract is also the one built by AAR, so it's the Arizona Association of Realtors. It is to be used exclusively by realtors. So it's not something when your sister says, "Hey, I want to put an offer in, and I don't need a realtor, and I don't want you to represent me because I don't want you the responsibility, but could you get me the purchase contract?" She's not allowed to fill that. She's not allowed to use it. So it's really something that's only designed to be used by members of the Arizona Association of Realtors. It can be used anywhere in the state of Arizona. With that said, you are licensed to buy or sell or represent people buying or selling any property anywhere in the state of Arizona, and you don't necessarily have to use the AAR purchase contract. It is a fantastic document. So I would say even those that are off market or outside of MLS or something like that, using that AAR purchase contract is highly to your advantage. So even FISBOs and stuff like that use it. So first thing I'd like to, well, that of course was the first thing. First thing contractually, what I'd like to go over is really your presentation to your client as far as the prep to them. the time that they're filling out that purchase contract for an actual offer for your buyers should not be the first time they ever see the purchase contract. So I highly suggest handing them a blank version early on in your relationship and just saying, hey, this is a document you're going to be filling out later. Read it sometime. It is, blank. It's filled with a bunch of questions, and at least when it counts, when it's serious, it won't be the first time they've ever seen that document. Depending on time allowance and things like that, I used to go over the purchase contract in detail, or in as much detail as I could for that client before we actually filled it out. And if you have that time, like if you're in that buyer consultation, you want to go over the purchase contract so they know what they're getting into, then something like what we're doing now is going to be that. Now you wouldn't spend an hour going over it, but you're going to be able to hit the high level details as far as what things mean the most to them throughout the purchase contract. So now, without further ado, I've already chatted a little bit, so I'm going to dive into the actual contract. Bear with me. I'm going to flip over to share my screen through Zoom here, and should be that one. There we go. All right. So you see the purchase contract here. It is, like I said, it is 11 pages. This first page is basically a mini buyer's advisory. It is not the buyer's advisory, but it's something it should light up some flags for the buyer. Read the entire contract, review the SPUDs, read the inspection report or the inspection paragraph, knowing how serious that is and what the timelines look like. Confirm your ability. So go through all of these things. These are just big reminders to your buyer about contract stuff. Then actually, page 2 of this document is actually page 1 of the contract. So this first page is not technically a part of the contract, it's the buyer attachment. You don't have to send this over. That also means you have to split the document, and a lot of people just don't want to do that. So sending this over is not that bad of a deal. It's not a deal breaker. All right. So we're gonna dive into some of the stuff. So the very first stuff is pretty easy. The buyer's names and the seller's names. These should be the names as they are on the tax assessor on the deed, right? So that is the entity that is conveying the property. So if it's a trust, then it should say, the Altman Family Trust. That's the seller, right? If it's if it's 2 people, then it should be those 2 independent people. Ideally, it should be not a Bill and Jim, Smith. It should be Bill Smith, Jim Smith, right? So it should be those 2 individual people. So I ideally split those up in both buyer and seller. If your buyer is wanting to buy it in a trust, make sure you clear that with all the other parties involved, like your lender and your title company, to see what's needed there. The lender may not want them to buy it in a trust. They have to buy it as a person. Then they can go put it in a trust afterwards, but they have to purchase it as a person. So make sure you check on that. Next little bit, premise address. So premises is, you put in their normal address, the assessor's number. Most of that you could pull from the MLS, or you can go pull that off the assessor's website. City, county, zip code, all that kind of good stuff. Legal description is the actual legal description. So depending on where you are, that may be lot and block, that may be rectangular survey, that may be whatever else you can have, meets and bounds. Some of them are. So make sure that's in there. It's got 3 lines there, and if your description is longer than that, then you can just say see section 8, where it's got a bunch more lines where you can put the actual full legal description in there. Next little bit here, lines 10, 11, 12, 13, 14, 15, 16, all that kind of stuff. So these are a bunch of blanks. So line 10 is the full purchase price. So that is your offer, right? That's your full purchase price. So if your buyer said, I want to offer $475,000, then that line should be $475,000, right? The next line, line 11, is your earnest money. So that is how much money are they giving in their earnest. So earnest money is your skin in the game. It's how much money you're putting into risk, that if the buyer were to flake out and leave the contract not under any terms in which they were allowed, that would be the number that they would forfeit over to the seller. Now, there are many tools in the contract that are made to allow that buyer to keep that earnest money, cancel the contract and keep that earnest money. So remind them that they have the ability to keep that earnest money as long as they follow the rules of the contract. And it's your job, you as the realtor, your job to help that client follow those rules. It's also their money, right? So if they put $10,000 in earnest money, they get 10,000. Like it's still their $10,000 at the end of the transaction. So that's what plays into the next line, line 12. So I'm going to assume this is like a financed offer. So we've got a $475,000 purchase price. We're going to put $10,000 in earnest money. They want to put $75,000 down, right? So I'm making that number up. Well, if they've already given them $10,000 in earnest money, then they only need to bring another $65,000 to the table. So on line 12, you would put $65,000 additional down payment and as cash, right? And then line 13 would be the balance, which is whatever is financed, right? So there would be a 475, 10K earnest, 65,000 additional down payment. So you've got a $400,000 loan that you're going to take out. That makes sense? I hope so. So if it's cash, 475 cash, $50,000 earnest money, $425,000 cash to a close of escrow, right? So when you think about that, lines 11 through whatever below that, 11 through 13 or 14, 15, 16, if you have other things, should all add up to line 10, right? So do that, make sure you do that math right. If you said 475 purchase price, 10K earnest money, $75,000 down, and a $400,000 loan, you've got 10,000 extra dollars that are floating that we don't really know what to do with, and you're going to have to correct it down the road. All right, so the next bit, lines 14 through 16 are really just, if you have additional terms, if it's seller financing, if you have other ways that you're getting that money, that's just additional ways to manage that. Rarely used, but they're in case you need to use. 17 and 18, how is money going to be? Personal check, earnest money, personal check, wire transfer. You're going to deposit with the escrow company or broker's trust account. Us at KWBP, we do not have a broker's trust account for purchases. We don't even have one. So that's not an option for you. So it always goes to the escrow company and never goes to the broker or the agent. So I would honestly appreciate every agent out there. You never touch the earnest money, right? The earnest money should go straight from buyer to escrow company, not through you, not I'll deliver it, not hand it over to me, I'll take it over there. None of that. It should just go straight from buyer to escrow company. All right, next little bit, close of escrow. So this is putting it out there, right? When do you want to plan on closing this? If this is a finance transaction, 30 days. 30 days is about average, right? Some can close it in 22 or 23. Some take 35. It just depends on your lender. You might give your lender a call and say, hey, if we go under contract, this contract executes tomorrow, what's a good closing date to pick? My rule of thumb is I go 30 days out and then pick the following Thursday. Right, round it up to a Thursday. There's just cuts. Thursdays are good days to close on. It's not Friday. People aren't slamming. If there was an extension, something that you had to do, you're just extending one day to get it taken care of on Friday. You're not extending over a weekend. And Thursday also allows the Monday, Tuesday, and Wednesday as work days for you, for escrow company, for lender, to make sure everything is going right. All right, if you have a closing on Monday, your last contact was on Friday, and you got Saturday and Sunday that people are kind of in ether. They may be working, they may not be working. So it's tougher to work out. So I try to aim at Thursdays. All right, next little bit, possession. 99% of the time we are taking possession at close of escrow. And this just came up recently with another transaction. We are doing post possession, and that's more common now. It's not something I love as a broker, but it's something that exists out there, and it's a market at the moment. So, and that is the seller staying in the house after it has been sold, most likely to give them time to go find the house that they're going to buy, right? So, somebody asked, should I just use line 33 to change when that possession happens? Well, all that does, if you were to use line 33 and that date becomes 2 weeks after the close of escrow, all that does is change the date, but it doesn't define any of the other details. Are there fees that are involved? Who's to have insurance? What about keys and things like that? So it doesn't do a very good job of actually defining that post-possession. So I prefer not to use this. I prefer to actually have close of escrow and possession change, and then have a post-possession agreement that's separate from this, that's between buyer and seller, that establishes what those additional days after close of escrow and transfer of title look like. We can talk about that later, of course. All right, addenda incorporated. These are the pretty standard ones. Additional clause, buyer contingency, all that kind of good stuff. If it is built before 78, make sure it's lead-based paint. If it's got an HOA, click HOA. If there are any other addenda, put them on here. As a point of professionalism and knowing what you're doing, make sure you don't click other and put things that are not addenda. So notice it says addenda. So like the market conditions advisory is not an addendum. It doesn't edit anything, right? It doesn't add anything, doesn't subtract anything. It's an advisory. Our KWBP UDS is not an addendum. It doesn't edit anything. It's an advisory. It's a disclosure. It's a disclosure statement. So I would be cautious to put things on there that are not addenda, because they it's just kind of like not following the instructions perfectly. Anyways, that's neither here nor there really, but check the ones that apply. The next big section, top of page 2, 1G. This is really very informational for your buyer. These are the things that typically convey, right? So built-in appliances, freestanding ovens, smart home devices like your doorbell or your thermostat. Those all convey. Speakers that are flush mounted. Notice this one right here, wall-mounted TV brackets and hardware, excluding the TVs. So this is not a fully inclusive list. This is just a good list to give you good examples of the most common things. This wall-mounted TV brackets and hardware excluding TVs kind of lives by the rule of, if it takes a tool to remove it, then it should stay, right? So most wall-mounted TV brackets, you can lift that TV off there. It doesn't take any tools to do that, but you would have to have a tool to take the bracket off of the wall. You can take the TV off the bracket. So same thing, you don't need a tool to take your curtains off the curtain rods, but you technically do need a tool to take the curtain rods or the curtain rod holders and stuff like that out of the wall. So the rods stay, the curtains most likely go. See, it says towel, curtain, and drapery rods, but not the actual drapery. Understood? All right, so there's that. If owned by the seller, these other things are included. The alternate power systems like solar or wind or something like that, in-ground pool, so hot tubs and that kind of stuff, and all the equipment. Any sort of water purification system, water softeners, if they're installed and they're owned, they convey. There's a different spot down here that talks about leased property. Leased items shall not be included in the sale. Seller shall deliver notice of leased items within 3 days after contract. So if you, by default, the boilerplate language is that the leased items don't include, so you have to add them in to the contract, right? So if you have a leased water softener, then by default boilerplate language on the contract, that water softener does not convey. So if you are planning to convey it, then you just need to write it in the in the section 8 or whatever you like, right? There you go. These other additional existing personal property lines, 56 through 60, 56 through 59, those are common ones, and then 61 and 62 are some additional things if you had other things that you wanted to make sure convey, right? Like the chandelier or the speakers that are mounted, or that are not mounted, that are sitting there, or whatever you like. Line 68 is a very key term. If this is an all-cash sale, section 2 does not apply. So go to section 3. So the entire section 2, which is all of lines 62 through 114, none of those apply if this is an all-cash sale, right? So that means the cash sale does not have a loan contingency, does not have an unfulfilled loan contingency, does not have anything about loan status updates or anything like that, doesn't have anything about loan costs or even seller concessions. Notice that, like the seller concessions section is in the lending section, so that doesn't apply. If you are doing seller concessions with a cash, that's weird because you would just change the cash amount. But if you did, then they would have to be added into Section 8. The appraisal contingency does not apply. So there is no contingency for appraisal for cash. You can call it appraisal just to know what you're buying. You just can't use it as an excuse to exit the contract. If you are lending, this is where it defines some very specific things. So it says an AAR pre-qualification form is attached here too. Reading that sentence, I hope that conveys to you that there's not an option of whether or not that is attached. It is attached. It is understood to be fully attached, so it's there. The loan contingency gets in there and just says, hey, we're going to do our best, and we're going to deliver documents 3 days prior, and we have to be able to attain lender approval without prior to document conditions and all that kind of stuff. We're going to try to do that 3 days prior to close of escrow. The Section 2C says if we can't do that, then we have the buyer has the ability to exit the contract and get their earnest money back. 2D is pretty key. Buyer agrees that the inability to obtain loan approval due to failure to lock the interest rate and points by a separate written agreement to the lender, or failure to have the down payment or other funds due for buyer's necessity to obtain loan approval without conditions closed is not an unfulfilled loan contingency. I know we read through and mumbled through that. That basically says interest rates and your ability to find enough down payment are not reasons to get out of this contract. Let that sink in. If you don't lock the rate and you get a rate that's too high and you just don't like it, that you can't use that as a loan contingency. You can't use that to get out of this contract. If you said you're going to put $75,000 down payment, and then all of a sudden you don't have $75,000 to do it, you can't use that as a reason to exit this contract. You've got to either find that $75,000 or you've got to find some other way around it, right? But you can't use that I don't have the down payment as a way to get out of this. Now, you can get out of it. You're just going to forfeit that earnest money, right? You're just going to hand over whatever you left as earnest money. All right, loan status update says that you're going to get one within, or the buyer is going to give one to the seller within 10 days of contract acceptance. It does not say that you're going to continually do that, but it does say that they're going to at least supply it at, by day 10 of contract acceptance. So keep an eye on that. As a realtor, you should be in charge of that. Good lenders will supply at LSU usually like once a week, so you're never more than 7 days away from LSU. Talk to your lender about that and ask them if they are, especially if they are a lender that's like an online lender, like a Quicken or something like that. Just ask them when do you offer LSU, and see what they come up with. This does say the LSU with lines 1 to 40 completed, so it is talking about a specific AAR LSU. I would suggest using that. If you don't use that, then expect pushback from the seller to have you provide it. Loan application, you're going to get the application done. Loan processing during escrow, you're going to try to get everything done. Type of financing, check which type of financing it is. Seller concessions, this just says a percentage or a dollar amount of seller concessions are going to be used. They basically can only be used for costs that are incurred by the buyer. So they can't be used to just go in the buyer's pocket. So be aware of that. If they say, yeah, we'll give you $10,000 in seller concessions, and the buyer only comes up with $7,000 worth of costs, then only $7,000 crosses the table. That extra $3,000 stays with the seller. Changes need to be conveyed. Appraisal contingency. This just basically says if they're guaranteeing that the premise, not guaranteeing, they're saying the premise must appraise for at least purchase price. If it doesn't, then it gives the buyer a reason to back out of this contract. This has been a key clause that's actually been pulled out of the contract by using another document, the additional clause addendum, lately just because of the market in the moment. So people that are financing are removing that appraisal contingency. So they're not letting the appraisal actually allow them to exit the contract. So that's how that's sitting. This does that. So that allows them to exit the contract. Really, in reality, what that does is it brings up another negotiation point, right? You've got a purchase price at 475, appraisal came in at 450. Now the buyer can approach the seller and say, hey, this came in at 450. We're at 475. We need to renegotiate something or we can cancel, right? So the seller is motivated to put a little bit of effort into that renegotiation in a normal market. In this market right now, they're not. So that's where it goes. Appraisal cost shall be paid by the buyer or the seller. They typically are paid by the buyer now in this market. And this next lines 112 through 114, if that appraisal cost were to be pushed to the settlement statement, this is just asking if it's something that can be covered by the seller concessions if there were any. Right now, because of the push on making sure appraisals happen as fast as they can, typically a payment for the appraisal is done at the time of the appraisal. So we're not seeing those transfer to the settlement statement as much. If you do use Keller Mortgage calls the appraisal on day one no matter what. They pay for the appraisal, so it's done, and they get things moving as fast as they can, and then that payment back to Keller Mortgage is on the final settlement statement. So what that means is, one, appraisal gets called as fast as humanly possible. They're not waiting for anybody to pay for it. And two, that means the buyer only pays for the appraisal if they close on that house. If for some reason they don't close on that house, then Keller Mortgage eats that appraisal cost. Pretty cool, huh? All right, next little bit, title and escrow. This is your escrow company. This is when you as the agent say, hey, Mr. Buyer, do you know anybody in title or escrow that you would want to send business? They say, no, I don't even know what that means. Cool. Well, I have a few different providers that have treated my clients very well. Would you like me to suggest one of those, or would you like to look through ones that exist? They typically say, whoever you like is great. Excellent. What's big about title and escrow companies is that open communication. You can work with them, you can call on them, you can ask them questions and stuff like that. So right now, with it being a seller's market, we're following a lot of the sellers' instructions. They've got their own title and escrow company that they want to use, which most of the companies now are doing really good, right? So I mean, they're busy, they're pushing. It's good to just stay on top of them and be that project manager. So you're involved and nothing gets tossed behind. But so it's partially your responsibility to keep on top of them and just make sure that line of communication is open. Make sure you do put enough information in this to create contact. So the title company, if there's a specific escrow officer you want to use, their email, their phone number. If you need their physical address, put on their physical address. It's good to have this kind of stuff put in as complete as possible. Title investing, title commitment, and title insurance just defines basically what they're getting with that title company, right? And the additional instructions, these are escrow instructions. So this tells the escrow what to do. Tax prorations, how things are done, release of earnest money, how that's handled, prorations, and all these kinds of stuff. Yeah. If you can't sleep at night, go read this. It's good instruction. It's good for you to know what they're supposed to be doing. Very little. Actually, I don't know if anything in here is anything that you do yourself as a real estate agent. These are things that the escrow company is going to be doing, and you should probably just read through this and know what it is that they're doing, because they are doing a lot. It's not like they just take money and then wait until it closes and then file some documents. They do a boatload of stuff. Disclosure, section 4. So this is really all about, Arizona is a disclosure state, meaning as long as the seller discloses everything they know, the buyer discloses everything that they have, they both understand it fully, then a real estate transaction can occur and nobody's held liable. So we want the seller to disclose as much as possible. This first section 4A said that seller is going to provide a seller property disclosure statement within 3 days after contract acceptance. I'm not going to get into the SPUDS document that much, other than just saying that my words to the seller are, the more information you put on this document, the less they can sue you for later. So that should encourage them to fill out that document as much as possible. Section 4B, insurance claims history report. So they're going to call up their insurance company and pull a 5-year claims history. If that's multiple companies, they can go down multiple companies. There are agencies that exist that will pull those public claims reports out. They cost money. You can usually get it from your insurance company for free. But if this is an investor and they really don't have anything, or they've only had their company for 6 months, they need 5 years, and they can't get a hold of the other company, then you can go down a third-party source to pull the claims history. One of them is LexisNexis, and we've had that done, and they're not expensive. It's not like it's hundreds of dollars. It's $40 or $50, and they pull a 5-year claims history report. Section 4C, if you have a foreign seller, this just discloses that something may happen. There may be more documents, and there's more stuff that goes on. Section 4D is all about lead-based paint disclosure. You only check lines 173 or 175 if it is built prior to 78. If it's built post 78, you put your initials on line 182, and that's it. That's the only thing you deal with in Section 4D. This does not absolve the necessary for a lead-based paint disclosure document, the actual document. That is a document that's required by the federal government. And for those of you not in the know, if you don't get that document filled out, it is a fine. I believe the last time I heard it was $16,000 per missing initial. And for the sellers, there's 1, 2, 3, 4, 5 places they go. Same thing for buyers. So take it pretty seriously. Next section, affidavit of disclosure or changes during escrow. This just says that these are going to happen, right? If it's an unincorporated area, then the seller is going to provide an affidavit of disclosure. Any other changes during escrow, meaning, if they, let's see, they disclosed in their spuds that everything was fine, and then, on day 3, a pipe burst and flooded places, right? Then that needs to be on the spud statement, and that's a change. They need to disclose that. So this does have a little bit more effect, because it allows for the buyer to have a 5-day disapproval time for that thing. So if something bad happened that triggers a new disclosure or an updated spuds, then the buyer gets another 5 days to disapprove, which means cancel, right? So that allows them to do that. All right, next section, 5A. Not a whole lot to put in here, just basically warranties. This used to be a much more lengthy part here, but in reality right now, this says that this contract is an as-is contract. There is nothing that the seller has to do, nothing that the buyer has to do in order to convey the property, right? So it's not forcing the seller to keep anything up in some sort of maintenance or capacity, just that they have the legal ability and they're following the other directions of this contract. There are warranties that survive closing, meaning that latent defects and any items of value, any material or adversely items of value, that kind of disclosure is still required. The buyer warrants that they can do this and not doing illegal things. I'm going to move on to section 6, due diligence. The inspection period. I had this conversation with an agent the other day. They said, what's the difference between an inspection period and a due diligence period? And in reality, nothing, right? So it's all an inspection period. It's all making sure you inspect the property or anything about the property that may inform a buyer's decision to buy this house, right? So I like to call it due diligence, just because inspection period sounds like it's relying just on the inspector, right? You're gonna hire a general inspector, and that's all it is. Whereas due diligence opens up that door. Maybe that buyer wants to drive the neighborhood during rush hour and see what the cars are like, or see what it is after kids get out of school, see what they'll walk home, or where the bus picks up in the neighborhood. Or maybe it's they want to be there during high flight times to see what the flight noises are around there, or they want to look up crime stats on communitycrime.net or .org or whatever. So it's their due diligence time, and like properties that have had things done to them, maybe it's that time to go permit search and see what licensed contractors existed, and mind you, the seller is not bound to give you just blurt out everything that they ever had to deal with the property. There's a certain amount that's required for disclosure, and then there's a certain amount that they may have that's not really required for disclosure that a buyer could ask for. The seller's nice, you ask nicely, then you could get it. Maybe like permits or the names of the contractors. Those are nothing that the seller is bound to provide to you, but it might be nice. So if you ask nicely, the seller has them, then that's great. If the seller doesn't have them, and the buyer feels like they need to know them before they buy the property, then it's up the buyer's decision, it's the buyer's responsibility to go dive into the city, county, municipality records and find whatever they need to find. So that's that falls into the buyer's court. And this is where you become the source of the source. So you don't go dive into county records. You don't go drive by the house. You don't need to do any of that. You're the source of the source. You can say, hey, if you're interested in permits, the Maricopa County or the city of Phoenix has this website that has that permit search on it. Here's the website. Go crazy, right? So you're handing that over to them. It does have boilerplate language saying the inspection period or the due diligence period is 10 days, and that's pretty standard. That's not uncommon. And I would say that's typically enough time to gather information and stuff like that. You can extend it. You can make it longer. You can make it shorter, however you like. These next few sections, 6B, 6C, 6D, are really disclosures to the buyer saying, hey, if these are important, you inspect it. That's square footage, wood destroying organisms, or a flood hazard. And actually see insurance. So if these things are important to you as a buyer, this is your time to find everything you can about them. And if you find something you don't like and that makes you not want to buy the place, as long as you find it within that 10 days, you can cancel and get out. All right, section 6F is talking about sewer connection, swimming pool barrier, 6G swimming pool barrier regulations. This is, again, more disclosure to the buyer saying, hey, if these are important, you go figure it out. 6H is really saying that the broker isn't your person isn't your expert on permits or pool barrier regulations. You are. So your broker can't be held liable for permits or pool barrier kind of stuff beyond our scope. Inspection period notice. That just means that before the end of the inspection period, buyer's going to supply the seller with, hey, we didn't like any of this stuff. Then section 6J defines what that back and forth looks like. We happen to use a document called the BINSR, Buyer Inspection Notice and Seller Response. And that is just a helpful tool document that follows the same rules that are outlined in 6J. Gives you some really neat areas to fill in, gives the seller some areas to fill in, the buyer a final area to accept. So that document is just following the same rules that are outlined by section 6J. Is an outstanding document, utilize it. Understand that the BINSR does not modify the contract. The BINSR follows these instructions here, and does set forth expectations, right? Expectations if the buyer said, seller, I need you to fix these 6 electrical outlets, and the seller said, okay, I'll do that, then it set forth the expectation that those will be done, right? And that is a curable thing in the end, as far as not if they didn't complete those things that were outlined in the BINSR. Fixing electrical outlets does not edit the contract. Changing the contract price or changing a concession from the seller to the buyer, that does edit the contract. So if you do have something that has to do with money or time extensions or anything like that, those need to be addenda that are added into this contract. So if your BINSR says, I want items 1, 2, 10 done, or give me $5,000 credit, and the seller says, I'll give you $5,000 credit, that's great. The BINSR document doesn't edit the contract. So then you also need an addendum saying, seller to credit buyer $5,000 at close of escrow. And that's it. So you need another document that will actually edit the contract details. All right, verbal discussions don't extend. Everything should be written, and buyer's failure to give notice of disapproval is deemed acceptance. So if you don't turn in your BINSR by day 10, you have accepted it as is. Is that understood? If you, and delivery is delivery, not just your client signing it, but you getting it to the seller. So you have to get it to the seller's agent on day 10. If it shows up in his inbox on day 11, and you know at 1 a.m. on day 11, you missed it. Too bad, so sad. 6K home warranty plan. It is pretty common to do this, and they wanted this put in the contract so that the buyers know that they have the option to buy a home warranty, and it kind of lays it out. It also is a very common charge to be able to put on the settlement statement, and so having that in the contract allows the escrow company to put it in there without having an additional addendum or anything like that. So this builds it in there. It does say you're going to order a home warranty. Who is going to order it, the buyer or the seller? Is it going to have any optional coverage? Who are you ordering it through? What's the max price of it? And who's going to pay for it, the buyer or seller or split, right? So you need to fill out all of those things. You are going to do a walkthrough. The seller's responsibility is to give you availability to it. That doesn't mean their doors are wide open. You know, if somebody actually lives there, then you need to ask them, right? Notify them and ask them to come over. And during that inspection period, the seller is really supposed to give you as much access as conveniently possible. But then outside of that inspection period, the buyer doesn't get willy-nilly rights to just go visit the place. So keep track of that. IRS and FERPA reporting, more IRS if you're a foreign seller, read that. Remedies, first little bit, cure. It says a party shall have an opportunity to cure a potential breach of this contract. That just means that a breach does not instantly invalidate the contract, right? You must give the breaching party or the potentially breaching party an opportunity to cure it, right? And the way this is done, or the way this is written, they get 3 days to cure that. So if there is a breach, you know, one side says, I'm doing this and that's wrong. The other side says, I'm going to cure you for it. You get 3 days to make it right in some way. And that make it right is just finding an amicable solution between the buyer and the seller, right? So it could be supplying the exact document that was needed that wasn't, right? Or it could be them creating an addendum that allows for more time or changes things so that is no longer a breach. We could go into detail on that, but the other very important thing that I want to say here is that if you are planning to cure, or if you do want to cancel a contract, then you must cure first, right? So there is no, oh, the seller didn't provide his SPUD statement within 3 days, so on day 4 I'm going to cancel the contract and get my earnest money back. Or the seller hasn't provided the SPUD statement, it's day 15, right? I'm outside, so I'm just going to use that, I'm outside of my bins, or I'm just going to use that reason to cancel the contract and get my earnest money back. Nope, that's not what it does. You give the opportunity to cure, right? So you cure them. They get 3 days to cure it, right? To supply you that SPUDs if that was a situation. If at the end of 3 days they don't supply it, now you cancel the contract and move forward. But you cannot cancel the contract without first providing the cure or the cure notice. All right, breach. This defines what a breach is. Alternative dispute resolution just says that we're going to try to do an alternative dispute resolution rather than going to court or mediation or things like that. And what kind of rules we're going to follow. There are exclusions of that, attorney's fees and costs. This is a bunch of legal language. You know, read it, know what it is. Probably never going to apply it. Yet, when problems do arise, we are going to focus on what these things are. So know what they are. Section 8, page 8, section 8. Just a bunch of lines. There's not really anything in here. Right? Additional terms and conditions. They put a boatload of lines here. This is for you as a realtor to add whatever language you want to this contract. I think I talked about this in another episode. It was about make sure this language in here is clear and concise and actually conveys what you want. In fact, if you write something in here, go have somebody else read it and see if what they pull out of it is exactly what you wanted to convey, right? You know, who it affects, what, by when, and what's the result, right? So make sure they're in here. You use this section for anything from an escalation clause to disclosing that one of the realtors is related to one of the clients, to adding in some more terms like the horses are going to convey with the property or whatever, because they're not real estate, they're personal property. So this can be used for a number of wide open things. You just want to make sure that it's clear, and it's clear that if something was not followed, you knew what else was going to go on. So if somebody broke the promise, if you say all furnishings to convey, well, that's cool, but what's all, and what are furnishings, and what happens if the seller takes the couch and doesn't leave it there, or they take the one that's in there and then replace it with a cruddy IKEA couch or something. So that may need a lot more terms and conditions built around it. So use this. This is a powerful tool. Section 8 is a very powerful tool to be able to create customized, very specific contracts. And in this market right now, a lot of that we're needed, right? We need to customize and create these contracts that are very specific in order to win them. And so it may be best to utilize your other resources, other agents. Send them to me, send them to Scott, and say, hey, I'm thinking about putting this clause in there to give my buyer the best possible position. Does it make sense? Does it protect my buyer as they go to? So don't go in that blind. The last page here, page 9, this is the last effective text page, is a boatload of text in there. It basically says that we're going to follow the Arizona law, that act of God and stuff like that. We have other ways of handling things. There is going to be compensation that kind of discloses that. The copies and counterparts, how a day is defined, calculating time periods. This section 8I is a big long paragraph, but I like to just say, whatever day that you get it is day 0, right? So if you get the contract, if they deliver the contract to you fully executed today is day 0, 1 day is tomorrow. So it says you have 1 day to do something, you have until tomorrow, right? So today is day 0. So for all applicable time periods, if it's 10 days, then I say, all right, today is day 1, tomorrow, or today is day 0, tomorrow is 1, 2, 3, 4, 5. So that's how you walk through that. Cancellation, subsequent offers, these are all disclosures and says, hey, these things exist. Release of broker, this is our indemnity clause, so we can't, I'm not responsible if the roof breaks. It's not my responsibility. I'm not responsible for the condition of the roof, or even to tell whether the roof is good or not. That's outside of my scope and my professional capacity. Section 8.0, terms of acceptance. So this is basically when you're giving the other party, how long you're giving the other party to sign, right? And so this should have a date in it. And this is, in reality, when we're using this contract, this is a conversation you need to have with that selling agent to know what their timetables are. I mean, right now, sometimes we're writing offers on Friday, going and showing it on Saturday. They're going to take offers through the end of Sunday and respond on Monday. So as long as I don't, if I don't want to have to force them to create an addenda or a counter to address this, then I'll put my terms of acceptance to like Monday at midnight. To give it plenty of time. So they could just accept this as is and not have to modify it. If that acceptance date does get exceeded, if I gave them until 3 o'clock tomorrow and they didn't respond to me until Sunday at noon, then that some tool would have to be made, have to be written to extend that term of acceptance to include their acceptance time, right? We'd have to write an addenda, or they would have to counter it or something like that changed that term, line 437, to match the current contract timeline so that everybody is in there. This is the purchase contract, and we're going to actually, I'll talk about it there in a sec. So the last page is the signing, right? So it's got all your signatures. It's got your agent name, MLS code, the license number, your firm name, firm MLS code, firm license number. The agent, this has an additional agency confirmation, whether they, you represent the buyer and seller, that kind of stuff. Down here is section 9 is the seller acceptance. So the seller acceptance has the same kind of information. Line 467 is a big checkbox that says counter offer is attached, right? So that if you are countering, if you're not accepting this straight up, you want to check that box. And that tells anybody that's following this contract that there's additional stuff to this contract that needs to complete, that this isn't the whole story. How I like to explain it is that, your contract through the counters to the final acceptance should have, that tells the whole story of the contract. The counter doesn't have to redefine every term in the contract, just the things that it manipulated. So I offered 475 and the seller wants to counter at 485, then the counter just says purchase price to be 485, all of the terms and conditions to say the same. So I see the storyline. I've got my whole bit of information from my purchase contract, and then I also get to add that little bit of information from the counter that may edit a few lines on the purchase contract. And if it's counter 1, counter 2, counter 3, I've had up to counter 7, I think, before. And they all play in line. They're all there. That one of them, like counter 2, doesn't get rid of counter 1. Counter 2 edits the purchase contract and counter 1. Counter 3 edits the purchase contract, counter 1, and counter 2. So they all have to play into what is finally the agreed upon terms of the sale of this property. So that's it in a nutshell. I did that in a little bit less than an hour. That's good. I didn't actually type anything in here. I hope everybody at home could absorb that and take that in and really say, yes, this helps me fill out this contract. I hope more so it helps you understand what you're getting your clients into and the instructions in which you're going to follow. That you're going to be able to explain this to the clients, to your buyers, to your sellers, so that they understand what they're getting into, because that's really what we're about, right? This contract doesn't really need us. I mean, it is not required in the state of Arizona that you have a real estate agent in order to sell or transfer property. However, reading this contract does lay out all of the things that are necessary in order to do that and protect both sides at the same time. That's something that a lot of FSBOs don't understand. One of the most powerful things that I've used with FSBOs is leave them this contract and ask them, if you feel 100% okay with following all the terms and conditions of this contract, then go for it. If you have any doubt at all, then you need a realtor. And that's what we do. So there you go, bonus. Seller signs it, all that kind of good stuff. And hooray, we'd be under contract. There's the purchase contract in a nutshell. I'm going to put it up on, I'm going to put this up on YouTube and all that kind of stuff. If you like it, it'll be on my channel. If you like my channel, follow my channel. So we'll be able to broadcast this for a long time. This is a relatively new contract, February 2020. I don't expect it to be updated in any major capacity for at least a few years. They do update things every once in a while just to change some verbiage or to modify something that's small. When there are large purchase contract changes, they try to limit that to once every 5 or 7, maybe 10 years, and then they redo the whole thing. So this one's relatively brand new, February 2020. So we got a little bit of time built into this one, and we'll use it for a while. So always my door's open, my phone's on. Give me a call if you need anything, and go out there, have the confidence that you know what you're doing, and you're going to talk with your buyers and sellers, and let's get some offers written and get into contract. So awesome. I appreciate your time and energy and your ability to watch this with me. I'm going to stop the share so you see me as a person again. Thank you very much. And awesome. You guys are killing it out there. I'm very proud of the Biltmore Sales Group right now. We're doing fantastic, and we're really holding up a culture and a sign of quality in the whole real estate space. So congrats, good on you, and thanks. It makes me proud to be on this bus. Thanks a bunch. We'll talk again later. Bye.